Let's call to order the zoning bylaw committee meeting of December 19, 2022. Roll call attendance.
Clark Brewer here.
Tom Callahan is here and Jack Creighton is trying to get here. So we will have a quorum when it comes to the time we need a quorum. We also have our staff, Lauren Lind and Cassandra Thayer. We have Woody Chittick from our zoning board of appeals, and the Honorable Judith Cutler from KP Law is here tonight. Thank you for all being there. Try to make it as quick as possible. So the first order of business, our forum that we had 2 weeks ago, a week ago, no, yeah, 2 weeks ago. Any thoughts, feedback on that? A couple of things have come out of it. Steve Winter from the the alternate energy committee is hot to trot on us adopting the new, what's it called, Clark? The net zero building code.
Well, stretch code is what we agreed to do based on the Green Community Act, but it's net zero. So it's stretch code plus.
But the town follows the stretch code now.
Yep.
Okay. Well, anyway, we learned that that's all John Hallam's call about, correct, about whether we implement that building code.
No, I mean, the stretch code is the stretch code. We have to, we use it for buildings and houses. John Hallam enforces it.
All right. And for this net zero code, Lauren, go ahead and explain it.
So I spoke with John Hallam. I asked him what the difference was. The stretch code is what we do right now. And it was sort of an opt-in system where you can, like, throughout the state, that's what we did last time. John was saying that he would imagine there would be another sort of opt-in program. And if at that time, the town can participate if we want to.
Okay. Well, in emails after that meeting with Steve brought it up, I kind of said it's for Steve to deal with the building and, with John and Clark. I had connected the two of you since that was your part of the presentation. I don't know if you want to still work with Steve and just, follow up on this as we need to follow up on it. If you think it's something appropriate for John and the rest of the town to consider adopting, then, or opting in.
Well, I'm not exactly sure what the mechanism is. When we became a green community, I think it was a vote at town meeting because of the implications of the stretch code. And so an amended stretch code might be a vote at town meeting too, not just adopting the requirements.
Okay.
Yeah, I'm not. Yeah.
Well, I don't want to dwell a lot on this. Not a super high priority, but Lauren and Judge Cutler, any guidance we have and what we would have to do, and let's find out first what we have to do, and then decide whether we're going to do it.
Well, I thought it was.
May I speak?
Yeah, go ahead. Okay,
thank you, Tom. I'm not sure if we have the ramifications of net zero. I'm not sure that that's a pretty significant and major change in the way everything in town is governed. So I'm not quite sure that it makes a lot of sense to just throw in a net zero into a code without it being thoroughly vetted. I'm not sure that that's what our state is.
I kind of agree with Jack's sentiment that we should really look into it before we overwhelmingly say, yeah, we want to force people to do net zero now. Not that I don't think it's a good idea. I really think that with these kinds of things, the carrot instead of the stick has some benefits, and there may be ways to incentivize. Let's face it. I mean, making super efficient brand new buildings and houses is way easier than retrofitting all the energy hogs that we all own. So
yeah. All right, well, I'm not suggesting we rush into it. I am suggesting study of it. Do we want to let Steve run with the ball with that Does anybody want
I
to
would
work with
say,
Steve
I like
to run the bill?
I like Steve a lot, but Steve is a very, very, on this matter, very partisan, and I'm not sure that he is the appropriate person to give a dispassionate examination of something that he's passionately committed to doing. And I don't think that this zoning bylaw review and updating should be a mechanism for this type of thing. What the mandate of this zoning bylaw committee to take our zoning and modernize it and rationalize it, and it works. These types of issues, if we decide, town decides later on, they're going to have to be thoroughly and this isn't the time to.
All right, if this committee doesn't do it, the Alternative Energy Committee doesn't do it, it won't get done. Fine, I understand. Let's move on.
It may or may not be done, but it's not the purview of this committee to do that,
Okay.
nor to spend all of our time on this particular issue.
Much as
We got a lot of work.
which I tried to shorten this conversation about it.
Good.
All
So
right,
we'll move on.
so the other things that came out of that, I mean, we learned that the state has already got a toolkit with model bylaws for climate change and resiliency. I think we need to look into all of that and start working on cohasitizing it for some proposals and as part of the package in the fall town meeting. I don't know if anybody wants to take that up. I'm certainly willing to take that up. Separately, Clark, I'm assuming there are some bylaw ideas about low impact development. And I don't know if you want to still carry the ball on looking into those further, again, with the fall target. But as we heard at our last planning board meeting, not only a fall target, but if we can persuade a certain developer, if they do in fact come to a subdivision plan, perhaps, looking to implement some of these new ideas, even now with a new development that may be coming down the road. So,
Well, I think that this may be something in the subdivision regs, like an amendment or a subsection of the subdivision regs,
all right,
as opposed to zoning change.
okay.
Subdivision regs are just the regs that we update from time to time.
All right. Why don't you continue to carry the ball and looking into and making any recommendations for changes in that area? As far as climate change and resiliency, I'm willing to look at the toolkit and see what it has for us. Anybody else who would like to participate in that, welcome to the process. I don't need to do it alone. So,
Charlotte,
Yes,
Hector, and I also plan to look at that as well, so we can
Good.
discuss that.
Good. All right. Any other thoughts other than, I wish we had more people at the thing, but, and I've talked to Justin about more outreach and what we can do, but, I'm also of the mind that we can lead a horse to water, but we can't make them drink. I mean, we're making every effort in the modern communication age of reaching out to people about this, but, it was a great presentation, Clark. I think yours was great, and Tom and
Thanks.
the person we had from MAPC, I think it was very informative. It certainly was for me. And, we'll just have to go forward with, doing what we can to get people to participate in these things more. But regarding forums, just quickly, we're planning one in late February to roll out these spring articles, which should be done by then. Given that we are now putting into the spring package Article 8, the non-conforming section of the bylaw and the part that has the single lot exemption, I'm going to suggest we do a standalone forum on that topic, since when the zoning bylaw working group floated the idea of dealing with the single lot exemption, it was one of the only times we got public participation in one of our meetings. So I think it is going to be a hot topic, and I'd like to suggest that we deal with that as a separate forum from the rest of the articles. And when we talk about the calendar later, which we don't have to do with Judge Cutler and hold her up, I'll suggest a date for that. But that would be the next two forums, all related to the Springtown meeting. And after we get the Springtown meeting either prepared or done, we're prepared for it, or it's passed, then we'll get into some more substantive stuff leading up into the fall. All right, so unless anybody else has any other comments to offer about the forum, we'll move on. The agenda is a little out of whack, and I don't know, I'm the one who said it, so I'm not sure how it got out of whack. But tonight, what we'd like to do is vote on the articles for the amendments to Article 1 and 13, which is a combined article, Article 12, and Article 8. Judge Cutler, correct me if I'm wrong, Article 3 isn't ready yet. You're muted. You're muted, Judge. There you go.
Article 3 is still in process. We're trying to figure out some of the titles of the maps and make sure we get those updated. And I've got a couple of questions for the committee on Article 3. If you wanted to go into those either tonight or later, whatever you.
Well, I'm thinking in our schedule we will deal with articles, and the agenda says Article 6. I don't think we're dealing with Article 6.
No, we're not.
tonight.
We're not near Article 6
So
yet.
I'm looking at our next meeting in January dealing with 3.6 and starting on definitions.
Yes.
I'm going to suggest to the Alternative Energy Committee if they have any thoughts, comments, suggestions regarding the wind and solar bylaws, that they have them ready for our second meeting in January, and we'll deal with those on that night. But if your questions about Article 3 are quick, let's deal with it now.
Yeah, there's certain, but as I'm drafting it, I want to make sure I have things straight on what the town's wishes are on some of these. So if we have in the current bylaw, the interpretation of district boundaries, we talk about, one of them is where a district boundary is indicated at a specific elevation. It will be the distance above mean sea level based upon the Massachusetts geodetic datum of 1929. And I'm wondering, should this be updated in some fashion? We're still talking about 1929. Is that still the state of the art?
I think surveyors
Well-
use a more recent datum. Is it like, what is it, Woody? 2000, 2002. It's definitely more recent than 1929. So yes,
It's 1988,
in 1988.
and even
In
that's
1988?
woefully kind of out of date at 30 some odd years, but nevertheless, that's what everybody uses now.
Okay. All right, so if we can. If we
Could we
can,
also add language as updated as appropriate? Does that make sense, Judge Cutler? To have a
I'm
mechanism,
just, we're not really going over what we're gonna change, but I just wanted to sort of get some of this background stuff sort of squared away. And it also, refers to the fact that the floodplain map contains the locations to the benchmarks, and I'm not sure. And it's in sort of in relation to this geodetic datum, and I don't know how they combine. Laura, I don't know whether you have some information to provide me on that at some point.
Lauren?
So I don't on that topic, but I did want to note that as I was gathering this information, Judge Keller had reached out to me at the end of last week looking for the overlay information. We definitely need map updates in both the language and the map itself, because for numerous reasons, but as you look at the different overlays that are named, some of them are sort of like floating. They're not really, it's not a specific parcel. It's just based on geographic features, like a minimum, let's say, for example, 10 acres, and you have to meet these criteria. So it could be anywhere.
That really is not an overlay
Yeah,
district. I think we're
exactly.
good.
So, but the other ones that are, we have only 2 of them are listed, or 2 or 3 of them are actually listed in our official 2021 zoning map. And then the other ones, there were maps used to get them through town meeting, but they were never incorporated into the zoning map itself. So they, it's like you have to go hunting for the parcels, and they're named by parcel in the bylaw, so you can go and find them, but on the zoning map itself, it's not consistent across, you know, how it represents the different overlays.
So is that something that can be done in conjunction with this? Can we have at least a sketch plan of an update to
Yes.
present? Yeah, okay.
Yeah, and I guess long-term, we're gonna have to also budget a complete redo of the map when all of this is over.
Yes, and I honestly don't think that would be that much. We have an engineer that we can use that we're already on contract with, and I think that we could have that done, you know,
Okay,
in a short amount of time.
okay. Does that answer all your questions, Judge?
I think that answers my big question. Yes. I'm
Okay.
just trying to. Oh, no, I'm sorry. There's one other one, and it had to do with when a boundary lot, when a boundary of zoning districts divides a lot. And the language is a little is a little unclear as to exactly how you want to treat that. So it says, when a district boundary divides the lot at the time the line is adopted, a use permitted on one portion of the lot, it doesn't necessarily say in which district, may be extended 50 feet into the other portion. It's I'm assuming you're talking about the one zoning, the portion that's zoned in one district is extended into a portion zoned in the second, under the second district.
Yeah, I've read that over and over too. And a lot of the zoning bylaws that I've used, they basically say what the lot would take on the predominant area, whatever predominant zone the lot comprises is the zoning for that particular lot.
Yeah.
But ours does allow an extension from a zoning boundary. You know, presumably it would be like for a residence A or residence B, you know, where you're dealing with setbacks or something like that.
Well, what, refresh my memory. Where is that? What's the number of that? Is that a definition?
This
or-
is
bylaw.
300-33D. It is the boundary divider.
33D.
333D, I believe it is.
Okay, wait just a second. Let me just call it up.
Yeah,
I have D.
3.3.
Yeah, see, this has been used in times past. We haven't had anything recently where you have, it's not just residential district, you could have a commercial district.
Yeah.
Didn't it
And-
come
and
up with
that's-
Stop and
that's
Shop?
when this has been used in my recollection, particularly up in the highway.
Mhm.
So you could move up, or you could have residential conditions apply to a commercial or highway business or light industry district, or vice
Yeah.
versa.
Well, let me ask this, do we want to continue this practice or do we want to get rid of it? If we're going to continue it and Judge Cutler thinks it needs to be made more clear, then go ahead and do that. But
Well,
I
you've
think
got
the
two
only-
decisions, Tom. I think one is, do you want to continue it? And two, do you want to confine it to residential districts only, or you want to leave it as it is, which is any two districts?
yeah, isn't the only other time it came up recently was Stop and Shop?
Oh, the prison up there? Yeah, I think they did cite that, this condition.
Yeah, because
Yeah.
oftentimes, you know, it'll be a driveway or it'll be a setback or it'll be parking or something they want to extend.
What's interesting is you can't extend if it's in a water resource district, and like 3/4 of the town is in the water resource district.
Well, I think that's something we want to make clear. We're not talking about you can extend it into into an overlay district. I think you want to say you can extend it into the underlying district, because then if you run into issues with the floodplain district or the water resources protection district, that's, you know, it's another layer.
Yep.
And it may be a prohibited use in those districts for a very good environmental reason.
Well, let's do this, since we're going to deal with this at our next meeting. If you could draft something to just clean up what exists. But that
Yeah.
night, that night between now and then, everybody can think about, do we want
Right.
to continue
Think
this at all?
about whether you want to.
Deleting it's the easy part, but
Well, I don't think you want to delete it. I think you need that little flexibility sometimes, particularly if you have a lot that just meets the zoning area and frontage and has just a little bit left over and they need to shift for whatever reason. It's a flexible thing. Oftentimes, usually when you see this, you allow the less restrictive, you allow the more restrictive use into the, rather the less restrictive use into the more restricted district. So a district wouldn't maybe normally be allowed in, you can go up to that 50 feet and that's it, but not vice versa. But it, you know, we can do it either way. I just was wondering what your purpose was here and how practical it is and how often you use it.
But I mean, I think the one of the purposes is because the district lines don't necessarily follow property lines.
Right, right.
So-
And that's what that is, yeah.
But you don't
was
have the
just gonna ask
provision
them,
that
how-
covers if more than, if 50% or more is in one district, then that's what the district would be for that particular lot.
That's not how,
As many other zoning bylaws that I've seen have something
that's
like
not, how-
that.
that's not what your zoning bylaw says.
That's not what ours says. I know that, yes.
Which is
I'm
why
just
you're
bringing it
here.
up. I'm bringing it up
Yeah.
as an example for context.
I wonder, do we have a lot of properties where the properties bisected by two districts? I
Well,
don't
just
even
look
know.
at the zoning map. Yeah, sure, there's lots.
You know, this also happened at the Crazy Paws. If you go south, there's a residential district and it was wrestled with. I don't remember the resolution, but I think this was called into play there. I would just ask you, I mean, I don't have a strong point of view in this. What harm is there in allowing, let's say, the less restrictive a district to prevail when you have a division? I mean, I can't
Yeah,
think of
that
a
provides-
case
The
where
only
it's been
time it
hurt.
would be a problem, perhaps a problem, is if you had a residential district and the less restrict, I would call it a less restrictive district might be a business district. And so you're
Oh,
allowing some business
Like
Oh,
around the village.
into the residential
example.
district. So that's,
well,
you know, that's
yeah.
definitely,
well, it isn't just that. If you get out into the into some of the commercial districts, your lot coverage is a lot different. Height can be.
right.
You know, we have a restriction of no building in Cohasset can be more than 80 feet tall. Well, if you have, you know, you would hear
Yeah,
plenty if that were nestled in a residential.
I really think that the interest of the town really is to protect Cohasset pretty much as it is now. So I would normally be in favor of allowing the less restrictive, but I certainly see in this thing, in these examples, that you essentially take a residential area and you turn it into a business area. And I think the sense of the town is we want to protect the kind of the character of Cohasset. So on this particular issue, on this thing, I think we really do want to make sure that we have the more restrictive, because otherwise you're opening a gate and who knows how many horses are going to gallop out.
Yeah, I mean, one thing that helps is if you say that the property has to have its frontage in the less restrictive district in order to move it all into the other district. And that's one way to limit the situation.
Well, what about that if a lot exists in two districts and the owner wants to use the more lenient or less restrictive zone or district, that it come before the zoning board of appeals for a special permit for a
You
substantially
could do
more
that.
detrimental determination, because that's
You could do
that's
that.
really the problem where we have clashing between commercial districts and residential districts, and certainly tight neighborhoods and looser neighborhoods, where someone is doing something that might be completely out of character and
Right.
for its surroundings, that the ZBA would be able to make that determination.
Yeah, I'll write up two options for that. One is sort of just
Right.
strengthening what you have a little bit, and then the second option would be a more difficult situation, which would be a special permit.
Right, but the special
Yeah, I
permit still
would,
allows the option, so that still might provide the flexibility in case
Better
it
than a
doesn't make
variance.
sense. And that where people are pushing the envelope, they
Yeah.
know they're not gonna get it.
Okay. Okay,
And
I got it. Thank you.
Does that?
I would
that give
agree
you
with
enough?
Clark.
That's
I think
clear.
we ought to
Thank
do it.
you.
Okay, good. All right, so that'll be for our next meeting to deal with. All right, so for the articles tonight, what do you do? Are you going to sit in on all of them, or do you want to just deal with Article 8? I'll do Article 8 first if it.
Yeah, that would be to my liking.
I think Article 1 and 13 was taken care of last time it voted. I just sent you the draft warrant article.
Oh, okay, all right, so that's good. All
I
right,
think we're
so-
good on that. I think we could
Yeah, all right.
get that off the list.
All right, 113. So really tonight, we're just dealing with changes to Article 12 and Article 8.
Yes, And-
All right, great.
right.
So,
And-
Do you have a
so,
draft of 8?
yeah, there's been, I circulated things that came to me. So I don't know, Judge Cutler, who's
I
got
sent
screen
8 on
sharing?
Thursday and the red line version on Friday.
Yeah, and I believe I forwarded to everybody, but last week was busy. Forgive me if I didn't, but I'm pretty sure I did. But who's got screen sharing capability between Lauren and Judge Cutler?
I need 8.
Yeah, let's bring up the red line version of Article 8. Now, folks, if you didn't see it, it's got changes and really a shortening and consolidation of the rest of Article 8 that isn't the single lot exemption, and then Judge Cutler has some recommendations on the single lot exemption. And I know she met with Woody, things that came out of your conversation, pros and cons, love to hear it all. But I don't know if we can get it up on the screen. That might be helpful. Aha, Cassandra has it.
That's as changed without.
That's the clean one. Okay.
That's the clean one. There should be a red line.
Yeah, there's one with yellow, isn't it? You call it
Yeah.
red line, but.
Yeah.
It had redlining, it had yellow highlighting.
Oh, I don't think I saw the red part of it.
It had all the features.
Let me see.
It was the day before that one was circulated. I don't know, maybe I can pull it up.
Well, I went from the December 13th.
Was Friday the 16th, the Friday the
Yes.
16th?
Yeah, I have it. Cassandra, let me take a shot at if I can share it. Can everybody see that?
Yeah.
All right.
Yes.
That's the red
Oh.
line.
Okay, I hadn't seen this.
All right, that's the red line version. What Cassandra had pulled up was the clean version of it. So, Judge Cutler, I'll give you the floor because
Sure.
it's a lot of consolidation,
It's a lot of shortening, really.
shortening of it. And if you could just maybe start with the overall approach, keep the single lot exemption out.
Yeah, so that as noted in the diagnostic, there were a number of provisions in Article 8 that are really statutory provisions that are not related to non-conforming uses and structures and lots. It's really the zoning freeze provisions. When you have a plan endorsed by the planning board, it gets the benefit of certain periods of zoning freezes. So those lots are actually conforming. So there's no need to address them in a non-conforming section, first of all, but secondly, they're very short-lived freezes and they're governed entirely by statute. So it's really not necessary, in my opinion, to repeat it all in the bylaw. I think it sort of stands alone, and people who develop land are well aware of their rights to the zoning freeze. So in Article 8, we shortened up the title and shortened up a little bit and made clear that the planning board is always the designated special grant permit granting authority for the VB district in relation to non-conforming uses, structures, and lots, and the zoning board of appeals is the special permit granting authority in all the other districts. And so we just reworked that language. On the lawfully existing structures and uses, I treated them basically the way you already had, just that you can continue without, as long as you don't expand or change it, even though it doesn't conform to the zoning bylaw as adopted or amended. And then any construction or operations authorized under the building or special permit must conform to subsequent amendments unless the construction commences within 6 months. So that's pretty much what you already have. I moved on to the structural change, extension, alteration, reconstruction process as how you have to go before the zoning, either the zoning board of appeals or the planning board for a special permit for reconstruction. And if you have, unless you have a single family or two family home, in which case you can by right have certain reconstruction or extension or structural changes, as long as, whoops, where did it go? Should be B, a little bit below. Yeah, so the first one is any existing non-conforming structure that needs a special permit. The ZBA has to find it's not substantially more detrimental to the neighborhood. And then B, if we can get to that, I don't know if I can.
And all of this crossing out is just that the single lot is interesting.
Yeah. Okay, here we are, B. Yeah, B. So an existing non-conforming single or two family can be reconstructed, extended, or altered without a special permit, as long as the structural alteration or reconstruction itself complies in all respects to the current dimensional regulations, and it overall does not increase the non-conforming nature of the existing structure. Now, the question is going to come up, who's going to decide that? And clearly, it's really the special permit granting authority that ultimately will make the decision. Probably, if there's any question at all, the building inspector would send the individual to the special permit granting authority to make a finding that it doesn't increase the non-conforming nature. And if they make that finding, the person goes off and does whatever they want to do with it. If the special permit granting authority finds that it does increase the non-conforming nature, the next step is to consider whether to grant the special permit.
Right.
So,
But isn't that the process that operates today, that is in place today?
Pretty
It's
much,
still
yeah.
somebody's making a
somebody has
subjective
to make,
initial
somebody
decision.
has to make some kind of an objective decision. And I suppose if the building inspector said, oh, no, this increases the non-conforming nature, and they want to appeal it, you can always appeal that to the ZBA.
Right. Woody, in practice, are you finding any situations where a decision has been made, it's not increasing the nonconformity, and it never came to you and you wish it had?
Well, might have been a case or two or three. Sure.
I mean, is that something
Well-
we should take out?
Well,
of
I don't know.
this?
I think it's a question of judgment, and the zoning board would prefer to see gray area cases come to us, even if we conclude that, you know, there is no violation, rather than have that be done administratively and find out after the fact. well,
Okay, we could do that by simply putting it here, so long as the special permit granting finds that the proposed alteration or reconstruction does not otherwise increase the non-conforming nature.
Yeah, I think that's better to make sure everything, we get criticism as little as last week about that we're not making decisions and things are flying under the radar. So I'd rather that we are on the side of having things go in front of a board rather than not.
All right.
Building inspectors change. We've had different experiences with degree of enforcement and, and all towns do, about whether their building inspectors in sync with the thinking of their boards,
Right.
so I'd rather avoid those conflicts when we can, so.
Yeah. Okay, so that wouldn't necessarily be a special permit process, but it would be a finding, it'd be an application.
yeah,
for finding.
exactly.
Right. So it's just putting it in front of the boards instead of just
Yes.
one person. I think that's an easy sell to the public.
And we certainly have had a number of examples where we've met and say, really no relief is needed because,
Right,
and,
Exactly.
dispense with it in 20 minutes or something.
okay,
Yeah, I think that's very important, because the reason we empower the boards and committees is exactly for these types of reasons, to bring the community process and the community wisdom, like Woody. I like that, Woody.
Yeah, and
So definitely where we want to go.
yeah, the building inspector will say the same thing, that you've hired him for his expertise, but nevertheless, I think it's better with the boards than with the inspector, so good.
okay,
Um,
good.
If I could just jump ahead, so, I mentioned to you, and I don't know if Woody recalls this, I think it was the Jerusalem Road Lane project of the early to mid 2000s. And way back then, I had thought, clarify 8.7 and 8.9, to what scenario does each one deal with, but it seems like this is not doing either. It's basically saying any change, whether it's voluntary, involuntary.
You skip it, wait, Tom, you skipping?
Oh, I'm
December?
sorry. I'm sorry.
Sorry.
Never mind.
I think it'd be helpful if we could just go through,
Yeah, go ahead. Sorry.
otherwise we're gonna be back and forth and I'm gonna miss something.
I'm muting.
So, all right, so we moved on from change or extent as, change of extension of non-conforming uses. And so that's really pretty much as it is now. The special permit granting authority may grant a special permit to allow a lawfully existing non-conforming use to be changed to another use, provided that it's not substantially more detrimental than the existing use. I didn't leave in extension of a non-conforming use of a building to permit the extension. But do you want to do that? Do you want them to allow an extension of a non-conforming use?
I think that defeats what we're trying to do here.
How would you
Let me-
define
let
it?
me-
Allow
let me
some
ask Woody-
flexibility and or make things more difficult for people.
I don't know, Judge Cutler, how,
Well, I have
could you give me an
expanded.
example
Oh, no,
of an
I'm sorry,
extension that,
I should have been clear, to be expanded or changed. Okay.
so it wouldn't be just an
Yeah,
extension?
extension. I think of extension as a building. So I put expansion. Is that okay?
That's better. I mean, I think, and I don't want to sort of play amateur lawyer, trust me, but the Bjorklund case allowed an extension, but it didn't allow all that he wanted. It gave, it cited some
You're
examples.
talking about the building.
Yeah,
Yeah, I'm talking about the uses. So in your
just uses,
current
okay.
bylaw, you can authorize an extension of the use of a non-conforming structure, but I think what you really want is an expansion.
Yeah.
Okay, all right.
Well,
Okay.
I don't know. I mean, I'm not a member of this group. I mean, but I would
No.
think that's better. An expansion is, I don't know what an extension of a use is.
Yeah, I mean, you don't want it going into another building, or or out into the street or whatever. I don't know. Expansion just seemed a better word. So I just wanted to just point that out, that I changed that. Okay. So
Woody,
then we
don't sell yourself short here, Woody. Your board deals with this article more than ours. So you're really critical that you feel comfortable with what we're.
Yeah, well, that's, no, but I think what we're doing here makes sense, going through and what's, is this a cleanup? Is it clearer, or are we making a substantive change? I mean, I believe Judge Cutler hasn't made a lot of substantive changes. She's clarified.
I'm trying to shorten it and make it as short and sweet as
But if we
possible.
come to one of those others, then we can stop and say, wait a minute.
Yeah.
But I don't want to, you know.
All right.
I think it's important that we differentiate that Judge Cutler, a good part of her mandate is, of course, and she's doing a very good job, Judge, by the way, is getting our code so it's rational, it's shortened, and it makes sense. And I don't think we ought to be getting into a lot of very controversial issues in this phase of it. I think there are things we need to do later on, but for now, I'm very happy with the way the judge is putting this together. So thank you, Judge.
So now we get into a little dicier issue, the restoration of non-conforming structures. And I noticed it's pretty, your current bylaw is pretty open in that it allows any structure devoted to a lawfully non-conforming use, okay, or non-conforming building, if damaged, destroyed, or razed, now torn down to the ground, basically. And my question is, does it matter that can be restored or reconstructed? And does it matter whether the building is raised voluntarily or not? And I ask this question because if you have a non-conforming building and you decide, you know, I really don't like it and I just want to rebuild the whole thing and I'm just going to tear it down and then just rebuild it under this section. I've got 3 years to just put in a brand new building. Is that really a restoration of a non-conforming structure that was, you know, really, I think this is accidentally damaged or destroyed, or destroyed by a hurricane or a fire or something of that sort, or some kind of catastrophe, versus I voluntarily tore down my non-conforming building and now I want to put it back and reconstruct basically a brand new building, but the same non-conformities are going to exist.
Well, my only question might be here, what if both are in operation? I have a house that's badly damaged in a hurricane, but it didn't get, you know, razed to the ground. But in order to make it safe or to do something, I have to complete the destruction or raising process.
Yeah, well,
that
that would be the destruction. I mean, I would say, yeah, I see what you're saying. So if it's damaged, destroyed, or
it could be damaged to the point where it's uninhabitable, but it's still standing.
Yeah.
I don't know.
I think there's an element of voluntary. If it's voluntary, it's one thing. If it's involuntary, even if only half of it's knocked down, but the thing is, it didn't start as a voluntary, it was
Right.
involuntary. And then really, practically speaking, you have no choice but to do the
Right.
whole thing. That's one thing. Well, I don't think we want a situation where we say, hey, tear it down and then you can build something, you know, new in an area that we've decided is not appropriate for that neighborhood or business district.
So, all right, then I'll think about how to say that right. I mean, actually, if you think about it, if it's damaged or destroyed, it can be repaired or reconstructed, and reconstruction in itself indicates that you're tearing it down and starting up again. So but I didn't know whether you wanted it to be more liberal and to say people can do this as long as they build it back in 3 years. So I wanted to,
I think that,
before I took that out.
I guess my feeling on that is we know what the development threats are and how they're generally, how they happen. And if we give them to do it voluntarily, we're going to see a lot of quick tear downs. Whereas I think we want to protect somebody who owns a property and something out of their control happens, which does mean it needs to be rebuilt.
Mm.
But, and I don't know how we write the language that does that, but I think that's what that makes a lot of sense.
Could you put something in there as determined by the building inspector or something of that sort?
Required to be raised, maybe required to be raised.
Yeah.
Or, all right, let me investigate that a little bit. I just wanted to make sure that you didn't want to leave it as a liberal voluntary.
And comparing it to what we have now,
Oh, comparing it to what you have now, it's pretty much the same. I think I didn't
Okay.
change the,
we make a distinction between voluntary and involuntary.
no, you don't. Currently you have raised.
Okay,
Yeah, yeah, I didn't change that. I just highlighted it because that was the existing
Okay.
language. Yeah,
okay.
and
And I'm sorry, if we are adding this language about the building inspector or
Well,
required.
that may be a bad
Well,
that
idea.
are we making the distinction now? Are we now going to make a distinction between whether it's voluntary or involuntary?
I'm thinking how it's, what is voluntary? I mean, if it's uninhabitable. But
Well, what's voluntary is somebody comes in and says an ugly non-conforming house and wants to build a pretty non-conforming house.
yeah,
That's
the
fine.
voluntary.
I agree with you. There are stark examples that are kind of easy to say, yeah, that's right. But I'm thinking more of the gray areas where.
well, if
Well, I
it
think
has,
that's what-
has to be raised because of some catastrophic
Yeah.
event, that's different. That's
And
destroyed.
And if
Well,
there's
I like
wording,
taking it
yeah,
to,
I mean, yeah, if there's wording, you probably don't even have to state the building inspector, but that's the person who would be on the primary point there.
All right, well, I'll see if I can come up with something that's a little clearer on that to indicate that this is not just, I want to pretty it up
Right.
situation. Okay,
But the point of this is if you have an existing non-conforming structure that gets a tree falls on it or burns down or whatever, that you do have some rights to rebuild it.
right,
Um,
and
yeah.
that's what this would have,
But-
right?
But we're going to, again, I'm trying to get through all this discussion. We're going to tell the person who wants to voluntarily tear down the ugly non-conforming house that they're not going to get to do that. They're going to live with an ugly non-conforming house.
Or they seek a special permit for an extension or alteration.
Right.
I see. Okay, all right.
A
Understood.
section 6 finding or what, something along those lines.
Right.
Okay,
Okay, so then that repair has to be completed within 3 years. I just kind of moved
That's
that
fair.
down into a B. Okay. Oh, I had a question. Sorry, one question at the end of that one. What was it? Up just a little bit more. Up to 885. Yeah, so I had highlighted here, it says the site plan review provisions, the current site plan review provisions apply to any such repair or reconstruction in the business or light industry district. And depending upon what we do with the site plan provisions in Article 12 later on tonight, that may have to be adjusted accordingly.
okay.
All right, that's good. I took out the temporary structure because it's the same. I mean, it's the same issue as whether it's temporary or permanent. It's got to go for a special permit. So
Mhm.
non-conforming single lot exemption.
Well,
So-
let's hold off and let's jump ahead to a bit. Let's get
Wanna
everything.
jump ahead to
This
abandonment?
is the
Okay.
way I want to, it's kind of the way I want to separate this to the
Okay.
town in warrant articles. I don't want
Okay,
all of the changes to Article 8 to be rising and falling on the single lot exemption.
right,
I'd like to get half a loaf, if not the whole loaf. So,
okay.
all right, so let abandonment, so, yeah, let's just jump ahead to that. So, all
And we can
You
make
let
this 6 instead of 7 if you want.
right, so
Uh,
A, you want to move it, the definition here.
So right now you define abandonment in Article 2.
Yeah.
And regulations technically should not be found in the definitions. They should be in the regulations. So I thought, okay, then we really ought to treat it under Article 8 instead of defining it. We'll say what happens. And so we've defined it here. First of all, we're saying straight out, once you've abandoned a non-conforming use or structure, you can't revive or resume that. You're done. If you've abandoned it, you can't bring it back. And so what is abandonment? So first of all, a non-conforming use will be deemed abandoned upon its replacement with a conforming use. That seems pretty straightforward. The discontinuation or discontinuance of a non-conforming residential use, and you pretty much have this language, this is pretty close to what your definition is, of a non-conforming residential use for more than 3 years, or discontinuance of any other non-conforming use for more than 2 years will be deemed abandonment. An abandonment by discontinuance occurs if, one, there's a removal of the characteristic equipment or furnishings associated with that use without replacement and so forth within that 2 or 3 year period, or the non-conforming use ceases to operate on the premises for the applicable period. So let's say you have a restaurant, they may not remove the equipment, but they just stop operating and the place is vacant. So that's a little bit, it's a little bit more stringent, and we don't have to have that in there. Just say if you remove your equipment and furnishings and don't replace them, whether you have any use of the building or not, and return to operating that non-conforming use. So that's a question for you as to whether or not you want to do that.
I'm in favor.
40?
Yeah, I am too. I think this, particularly use, and I think, I don't know if it's statute entirely, but case law is pretty tough on abandonment of uses.
Yeah.
Abandonment of structures, you get into some gray areas, but.
Yeah. So one of the things with uses is there can be an immediate abandonment. Somebody, well, first of all, if you change to a conforming use, you've abandoned it, or you can just say, you know what? I don't want to use this anymore. I'm vacating the building. I'm gone. I'm in bankruptcy. I'm not touching it. Technically, you could say they abandoned it on day one, but why go there? Why have the fight? Unless someone is willing to, concede. This way it's clean and neat. It either operated or it didn't operate within that period of time, and then you're done. The non-conforming structure is a little bit more difficult, and I tried to address it here, but I don't know if I quite got what you need. So I've said a non-conforming structure that's been left vacant and unmaintained for more than 2 years will be deemed abandoned and may not thereafter be altered or used except in accordance with the zoning bylaw.
So what would happen, Judge Cutler, if they maintained it but left it vacant?
Yeah, I'm wondering if just the word unoccupied might be.
Yeah, unoccupied.
Just use unoccupied, forget the maintenance part of it.
Yeah. Well, if it's left unoccupied, somebody could say, you know what? I know it's a non-conforming structure, but I've been, I think Woody mentioned this to me. I got, someone left it to me in their will. I didn't really realize what was going on. It took a while for the estate to be settled. So it's been vacant, but I didn't have any intention of not ever using it again. So I put the unmaintained there just to say, look, if you've let the weeds grow and the roof, decay and the thing is falling apart and the broken windows, it's abandoned.
The only caveat to that I can think of is that what if the person has applied for a building permit, but she may need state approval if it's in a certain topography or something, and so things get frozen for a year or two while Chapter 91 process goes on.
Good point. Yeah. So you may not want to do that.
Well, if the intention is there to build it, but you can't get all your permits, or Concom hasn't weighed in, or there's a water resource district issue, or you've got to remediate that. I don't know. I mean, I wouldn't want to penalize the owner if that person is waiting for local or state or whoever has jurisdiction,
Yeah, well, we could go back to what you do, I think, in your definitions section. I guess you don't, no, you don't deal with that.
No, we don't. I mean, that's,
No. So you could say, I suppose, if it's been left unoccupied for more than 2 years, it will be deemed abandoned unless the owner demonstrates that reasonable efforts are being made
yeah,
to reuse it, something
Well,
of that.
I think
You know,
that,
one of the goals of this is to not make Cohasset an outlier, but if we build in an exception to this, are we going to become an outlier again where we're too generous?
I don't know if that's too generous. I think allowing someone to demonstrate, as you know, what he suggested.
I would word it in
in
terms.
before DEP for the last 10 years, and they won't decide on it.
if the
Yeah, but
person is
I'm-
making a good faith effort,
Yeah,
it seems to me, that person shouldn't be penalized. And I don't want to get into too many specific examples, but think about that building across the street from St. Anthony's. I mean, the guy's been hung up because it was I don't want to get in. He's claims to have been hung up because of the potential pollution from a prior gas station, and has had to been looked at locally as well as by the state. And he's basically frozen, my understanding is, until he gets a clean bill of health from 2 or 3 different agencies. I mean, he's got equipment there, kind of backhoes and things. It isn't like he's totally, but nobody's living there, nobody's using it.
Yeah, but I also wouldn't want to leave any situation like that one open-ended. That could go on.
Okay.
That could go on. So I mean, if we're going to give some exception, I would say, I'm trying to think of what's the word when the statute of limitations has stayed for a while. There's a worse word, but it's escaping. Told, that's the word. So you could say that the 2-year period could be told for 1 year.
mm-hmm.
And I would say specifically for probate purposes, if the property is inherited, and for permitting. Any local, state, or federal permit, as long as being pursued in good faith. But I don't know about leaving it open-ended. Good faith, you could stretch good faith
Entirely,
out for 5 years.
Yeah, now, today, John Hallen, as building inspector, has the authority to extend a building permit if it hasn't commenced
Right.
in 6 months.
Right.
So, and he weighs, I think, intention and impediments, it's fuzzy, but I think there's good faith effort, and then there's bad faith.
Well, do
or
you want to
total
leave
abandonment.
to an extension by the ZBA or the special permit granting authority?
Yeah. They could
Yes.
always come in and say, we'd like another year or 2.
Okay,
I think that's the way to do it. I
Because-
think we grant them the authority to do that, because we don't want to penalize people that things happen beyond their control, but we don't want to Tom's point, have an open-ended thing in which it can be lawyer forever.
okay.
Yeah.
All right, that
And you
works.
could say special permitting granting authority can give up to, I would put a limit on that too, and say maybe up to 2 1-year extensions.
Mhm.
Uh,
Well, why don't you just leave it,
We'll just
a
leave it.
1-year extension, and then it can be done again?
It could be rolled
I mean,
over. I
The
mean,
ZBA sees extensions of
right,
issued
well-
decisions all the time.
all right, well, I think Judge Cutler, you get the gist.
I got the gist. Yeah,
Okay.
okay. All right.
All right. So this is the rest of Article 8, and we would present it to the community that way. Changes to all of it, other than what is now the new 8.6, which is the single lot exemption.
Oh,
So-
yeah, okay.
So for our next meeting, then, there's some tweaks the judge is going to do. We'll vote on this quickly at the next meeting.
Mhm.
So now the single lot exemption I think should be standalone as presented to the community. It's going to be more difficult to explain. The forum I'm suggesting we add at the end of January would be simply with this article. And again, it would also be presented in 2 parts. All of these other changes to Article 8 and why they're being done, and then the single lot exemption. And frankly, that for that forum, unless you have other suggestions, Judge Cutler and Woody, I'm going to be looking to you to make the main presentation. I might do an overview, but the guts of it and the justification for it, the explanation of it.
I think one way to start would be for Judge Cutler to, my takeaway here is that this is mostly intact. And so it isn't as radical as.
It's not as radical
as
as you might think.
That's how, right, and that's how.
Which might make an easier sale.
That's at the
frankly, or
forum
explanation.
the forum at town meeting and at town meeting, I'd want to present it in that way. But it's still in 2 pieces because the single lot exemption, just based on our past example, when we had public input, it misinformed as a lot of it was, could sink the whole thing.
Yes.
And so I'd rather keep them as 2 separate warrant articles to deal with.
Okay, but why don't we hear from Judge Cutler in terms of
all right,
what
so
is substantively different as opposed to.
So right now, it's pretty open-ended. If you have a lot that was of record and conforming before a zoning change increased area width or frontage requirements, you can nevertheless go forward with building on that lot. However, it could be a situation where you had 2 of those lots that are both undersized or under frontaged or both, and they don't have to merge. Normally, they'd have to merge unless they meet the requirements of Section 6 of 40A, which is 1 lot, at least 5,000 square feet, at least 50 feet of frontage, and owned separately, never owned in common with another lot. So, as I understand it, this more generous provision has been around in one iteration or another since 1955. And I think it was probably put in there to assure people that, if they had a building lot, they would still have a building lot if they thought they had one. This wasn't going to change things for them. The problem is, if the lot had no frontage, if it was a back lot or what have you, and never had any frontage, it's still a building lot technically under this. If in 1955, when that first zoning came in, there was no frontage requirement, people say, well, I don't need any frontage, none of the frontage requirements apply to me. So we're trying to figure out a way to not let this same provision carry forward forever. So right now, if your frontage requirement is 150 feet or what have you, and somebody were to come in and record a deed of their property, record a plan of their property, showing it meeting today's requirements, if you were to change that area or frontage requirement 10 years from now, these people would still have valid lots, even if they own 2 lots together and could meet the new requirements. They don't have to. They can keep their lots and move along. So if you want to sort of close the barn door now, at least contain what you have, my suggestion is that you put in a sunset clause for when these lots or deeds were recorded. That'll at least stop this application from moving forward for new lots. I put in arbitrarily, I was thinking, we probably want to put a 2023 date in, possibly the date of town meeting, possibly, June or what have you, but that's something to consider. To do away with the whole thing would not work. And the reason it would not work is, as you know, there was a case a number of years ago, Torquand, I think it was, or I don't know, I think it was out in New Orleans. Yeah, and the problem was, even though the provision that had been very generous was in an old bylaw that had since been amended, and that provision was taken out of the bylaw, the landowner was astute enough to say, I have a non-conforming lot and I'm non-conforming way back 20 years ago. And I was fine then, and that carries forward. I haven't lost it just because it doesn't appear in the bylaw. So I don't think getting rid of this single lot exemption will do you any good just by taking out the wording. Again, it won't help anybody going forward, but people can claim it right back to the date of town meeting.
Just for background for Jack and for Clark, since you weren't on the working group, we pitched the idea of repeal. And we're looking at it towards December of 21's town meeting. And then Steve Bjorklund, who you all know, came to a meeting and brought up this SJC case. And it was Orleans. It was a bylaw very much like ours, that basically what ours does is abandon what's called the merger doctrine. And the exception, it blows up the exception that state law gives, because state law's exception puts a time limit on it. It's, I believe, what, 5 years from the zoning change, or in that case, they did January 1, 76 because the change in state law occurred.
That's if you're in common ownership, right?
Right,
Yeah, but
Right.
it doesn't. Yeah.
That particular case was 30 years after the fact of the repeal. And the person had rights to build on that lot before the repeal, and the court said, I don't care about the repeal. This person, if they had rights given by a local bylaw, they're going to keep those rights given by a local bylaw.
Yeah.
And so, you know, we had some people alarmed by that who showed up at our meeting, and we decided not to go forward with that until we understood it further.
Yeah.
So that's why repeal doesn't work. And I agree. And the exception that the exception that the state law 48 section 6 has, the key to it is a time limit.
Well, no, that
Well,
time limit certainly doesn't work anymore, because that was as of 1976, the later of 5 years, or 1976.
Yeah.
So that provision of the law doesn't even, nobody can claim that anymore. So
right, but that was the secret of eventually cutting off that exception to the merger.
Cutting it off, right.
Yeah, and so we have to do something, and like the judge's approach here is, we have to do something where we know from that SJC case that anybody who has rights today, and it's impossible for us to say how many that is without researching every piece of property in town. You'd have to review it on a case-by-case basis. But anybody who has rights today is still going to have rights, but we are trying to at least limit and cut off anyone who may develop rights in the future from exercising them ad nauseum into the future without some kind of cutoff point to either exercise your rights or do not. So I think, you know, this is one of the true outlier parts of Cohasset. We said it at our planning board meeting last night. We wouldn't be dealing with some of the issues we're dealing with on Black Horse Lane if it wasn't for Cohasset's version of the single lot exemption. Those lots would have been precluded by the state law a long time ago. So it comes back to bite us. We had a court case in 2017 on Jerusalem Road was the last court case about it.
Oh, yeah.
But you know, a butter tried to do it. The zoning board had no choice in the decision it made. The abutter tried to challenge it and lost because of it. So,
Could I ask does the right flow with the lot, or does it flow with the ownership?
The lot.
The lot. So I can buy and sell that lot, and okay, that's an important
And that's what they've
distinction.
done on Black Horse Lane a few times.
Okay.
Yeah, and I think going back to the bylaw working group, our bigger concern, it really came forth in that town meeting, is not to prevent mom and dad from, developing the back lot that they had owned for 50 years. But to prevent somebody who could comply under C3, the effective date, let's say there were lots registered in 1940. There was no planning board, there was no zoning board, etc., and no zoning bylaws. So all this was done separate from adjoining land, blah, blah, blah. And then later on in 2022, somebody comes and buys up a whole bunch of these little, half acre, quarter acre lots, but doesn't have to merge them. I mean, I at least that's my interpretation of C3.
Well.
Did that
C3,
happen, or
yeah.
am I misreading it?
As long as they had not less than 9,000 square feet
Right.
in the RA district.
Yeah, so
And
let's
they
say
have
there
a
are
bunch
a
of
bunch of
lots.
10,000 square foot lots that
Right,
were
they-
the hillside, for heaven's sakes, the veterans area. Although that might have been done after the zoning came in, so bad example, but could I accumulate these and get around that held in ownership? Because this separate ownership talks about at the date of the dimensional requirements or registration, and if the registration was in the 40s and there were no dimensional requirements, I don't know what stops me from accumulating.
You can accumulate, but you wouldn't be able to, going forward, accumulate lots that were undersized, that were established after this cutoff date.
Yeah, but I don't know if I defer to Clark and Tom. Are we creating any such lots these days?
Well, you won't know. You won't know until you decide you're going to change the zoning bylaw and increase width or lot area or frontage.
Yeah, I mean, no, we haven't done anything. So I don't know, on Black Horse Lane, there were Form As that were granted. I don't know if that did anything that impacts this discussion, but no, we haven't changed dimensional regulations since 1986. We may propose them, and that's, again, if we do indeed change dimensional regulations, we need to be prepared for the single lot exemption,
Argument, yeah.
So I don't, do you want to, so I guess in these changes you're proposing, you are, what's substantively changing other than putting in a cutoff date?
It's only going forward. This will not apply.
Okay,
You won't be able to create new lots
After 2023.
after 2023 and claim this in the future. That's all we can do at this point. I think if we try and do anything else,
Yeah,
it'll be subject.
reluctantly, I came to that conclusion, I think, after a discussion, but I mean, I wasn't happy, but I can see the box that we're in. But I don't know how many undersized lots the planning board is going to be creating through subdivision or otherwise.
They may not, but at least.
Yeah, no, I'm not.
Yeah, yeah,
taking
and
issue with your
it may
point.
not be undersized lots, it may be a lot width.
Yeah, it'll be some non-dimensional, some non-compliant.
Let me say this. One of the things that I heard in hearing about what was wrong with the single lot exemption is particularly the places where there was no frontage requirement or there was no
Yeah,
basic area requirement. And, these are egregious. It's probably not so bad if they have 125 feet instead of 200 feet, maybe the earth isn't going to come to an end. But when it's zero, it's a real problem. And even if they have 15,000 square feet, it could be a problem. If you've got septic systems, they may not be able to build on the lot anyway. They may wind up having to merge the lots. The access, however, is another issue. And so and this is something that we're dealing with on Black Horse Lane. You may have no requirement under zoning to have frontage, but how are you going to get to your lot? how are you going to access that lot for construction, for just coming and going and using the lot? Well, you're going to have to demonstrate, it seems to me, that you have legal rights of access, if nothing else. And so some of these lots may be back lots that got separated off years ago without the requisite easement. This zoning bylaw doesn't give them permission to cross anybody else's land if they don't have that right. So, just keep that in mind. And one thing perhaps in the future to consider, and I think it's probably a little ways off, but requiring that every lot that's built on has a certain basic access. In other words, for example, over an easement at least, if not from the street. So that's something to think about, at least to protect the town from having, fire access issues and things of that sort.
I think that's an excellent point. And I know of at least 3 things on Concom in which the access was really problematic. One of them, I think, is still in the courts. But yes, I think that's a good way that we should think, is that it has to have fire department suitable access could be required. It has to have access. It doesn't impinge on the wetlands. This will really mitigate a lot of the issues. And I'd like to see that we find out, just as you've done, Judge Cutler, what it is that we can do, and let's do what we can do. And then if we can't do more, but then let's look at these things like access where we can accomplish very much the same thing.
The idea that the planning board has tossed around about changing regulations regarding access hasn't gone away.
Yes.
My personal thinking is to more bylaw than regulation at this point, but that hasn't gone away. And when we get to probably Article 7, or maybe it will have to be some standalone section, Article 7 is where we deal with common driveway regs, subdivision rules, where we deal with those accesses. We still have a gray area of the roads in town that aren't subdivision control roads, but are not common driveways. So, when we get to Article 7 in the fall, I think you'll see that come back.
Yeah.
By the way, I just want to note for the record, I see that Dave Farrig, from wherever he was, has joined us. Welcome, Dave.
Hey, one thing that I noticed about comparing this section with 48 section 6 is that in the Mass General Law, it says area, width, and frontage, but it also has yard.
Yeah.
We don't have yard in our 2 or 3 versions of this.
No. So they still have to have
exception.
setbacks. They still have to have building setbacks.
But the yard would be yard, that would be a factor in setback, wouldn't it? As
Yeah.
opposed to what we have where it's not addressed. I mean, the single lot exemption is to provide a little bit more flexibility to section 6. Generally, towns have used it to extend and provide longer lasting value than what would be provided under section 6. That's the intent of it.
We can debate that forever about the philosophy of the single lot exemption, but it's basically, the state has this built-in grandfathering provision for certain lots. So
Right.
it is what it is. Let me ask another thing though about this change. The state law puts also in not only a date, but of the 5 years from the zoning change. One of the problems with ours that it's open-ended as to time when someone could apply to use the single lot exemption. And should we have not only the cutoff date, but also 5 years from the zoning change within which to act? We can easily point to the state doing that. So
That's a little different, because then you're taking away a once buildable lot.
But
Going
that's
the
what
other
the state
direction.
did. But that's what the state
That's
did,
what
and
the
we can
state
certainly
says.
justify it by
No,
comparing
no.
it then.
Actually, no, the state says if on the date you're compliant and you happen to have 4 or 5 lots, or I think it's 3 lots together, and you own them together, you have 5-year protection so that they remain buildable until you sell them off. Okay, and once they're sold off, that's it. They, they don't merge. But if you don't sell them off, they merge to meet zoning. It's not taking away what was once buildable. You're allowing them to proceed. Again, they have to meet the current requirements at the time that they are created, or 7,500 square, I think it's 7,500 square feet and 75 feet of frontage. And they allowed that to happen, but I think that was added back in. I think the 50 feet, 55,000 square feet, 50 feet thing was a standalone before that provision. That provision came in later, sort of, and added something back that hadn't been there before, and said you can do that for 5 years. The 50 feet of frontage, 5,000 square foot, was first, I believe.
All right, now, and, reasonable, I don't, reasonable minds can't understand the
I mean,
single lot, can't understand 48 section 6. so
I wouldn't, given that Orleans case, I don't know if I go try and buck that.
I
giving
hear
it
you.
a-
No, I hear you. I hear you, but that's one of
I
the.
mean, there's an
components.
argument. I think there's an argument to be made, and there's an argument to be made also that, you can't have 0, just like you can't have a 0, you can't have 0 frontage, you can't have a 0 width, you can't have a 0 area. If the town didn't have any area requirements, you gotta have something, and you did put in the minimum area requirement. But this is a difficult one. I'm not.
Well, I think Judge Cutler, from the perspective of the select board, what we want you to do is give us the best we can get that is absolutely defensible. And if there's other issues that we can't solve on this, we do otherwise, like your way of solving that with the regulating the driveways and the width of the access. So let's find out what is defensible, what's the best we can do that's reasonable without tying the town up in litigation for forever. But we want it bulletproof.
Yeah, I mean, what we want to do is at least stop it.
Yes.
If it's not working, we don't want it to continue. I guess that's
just like you to draft what we'd just like you to draft what is the best we can get. And then we won't have to be having town meetings for the next 15 years, having bloodbaths over the single lot exemption.
All right, Dave? You're muted, Dave.
There we go. Yes, I just want to say that, I mean, we all know this anecdotally, but the development pressure to develop a lot under the single lot exemption has exponentially increased over the years from where we were, say, 20 years ago. The value of a lot that sort of, rides parallel to it has gone up and up and up. So when you have a piece of land that basically is worth a nominal amount, when it's developed under the single lot exemption, it's literally like winning the lottery, where you can become a millionaire overnight. And so the development pressure on those lots is very heavy. And we have, I think, from the master plan that they did, I think it was about 76. There might be more lots in town that might qualify under this. But the question would have to be for those lots is why haven't they been developed today? And usually, not all, but I mean, usually the case is that they can't get a septic system in there and they're not in the sewer district. That's usually the case. There might be other reasons, probate or otherwise, but that's pretty much the main reason. So I think at this point in time, with all the development that we've had over the last 20 years, even with the extension of the sewer system in some places in town, which added to even more development, that it's, as Jack said, it's time to just get the best that we can on this so that, again, we're not here for another 20 years at town meeting and fighting over the single lot exemption, because unfortunately, no matter what the economy does, the lack of lots in this town, there's no more real estate being made, and that pressure is only going to increase, and the value of those lots is only going to increase no matter what the economy does. So I think it's time to nip it in the bud right now and deal with
I
it.
think the value of the lot has, as you say, exponentially increased a lot faster than other things. And if I own such a lot that was worth $25,000 a while back, and now it's worth $1 million or $500,000, I can afford to put a Title V system in. I don't need to hook up to the town sewer, assuming that I can, the land, the soil and everything.
I mean, yeah, but usually you need at least 20,000 square feet if you have a septic and a well,
Yeah.
it's hard to.
The problem with Cohasset is as the name goes, a ledgy place or a rocky place. We don't have the soils here like you do down in other places. So when they've tried septics in a lot of places, you go down 2 inches and you're hitting rock. So it's really there's not a lot of good areas in town,
Point well made.
Yeah, you need the area is more to it, and when you get these small lots, they generally don't have the area to fit the septic system with the house. So
Okay,
Yeah.
All right.
I buy what you say entirely.
All right, so we'll put the cutoff in. Do you want to put cutoff at town meeting date, or do you want to put up June 30th, 2023, or something earlier, the date of that you think it's going to be advertised for the public hearing?
The the public hearing advertisement is consistent with section 6, right?
Well, no, if you've got land, that's the problem. You're not talking about getting a building or use. You're talking about creating lots. And technically, anybody who has pending before the planning board any kind of a plan, a subdivision plan, is going to have a freeze on this anyway during the processing of the plan, and then if it's approved for 8 more years. And so even though the effective date was 2023 for them, it's really going to be 2031, I guess, for their lots to be used if there's a zoning change, if there's a subsequent zoning change. If there isn't, then it doesn't matter. But here, what we're really talking about is particularly somebody who might have a single lot that they're just putting on record, just to establish, I'm recording this deed, I'm recording this plan showing my single lot, or my 2 lots together. And so now I have this single lot exemption going forward. It meets the requirements today. They're conforming lots. But just in case the town decides they want to increase the lot area, frontage requirements, or the width requirements in the future, I've got this protected. And currently that means forever. With this, it means only within the time frame that's set here.
Might as well start.
Yeah, something's better than
All right.
nothing.
It's small.
Let's, all right. It's 8 o'clock. I want to move along. We have some other things. So let's do this. I would insert the end of fiscal year, June 30, 2023. That's a clean, understandable date. Like to entertain a motion to accept these proposed changes to our single lot exemption to bring forward as a separate article at the spring town meeting.
So moved.
All right.
Second.
Second, Jack, thank you. Okay. Alphabetical roll call.
Clark Brewer, aye.
Tom Callahan, aye.
Jack Creighton, aye.
David Farag, aye.
Okay, great. And Judge, thank you for tackling that subject.
Okay, so I'll get that.
You're not out of the woods yet, because you're gonna have,
Yeah,
you're gonna have to explain this to the public, help us explain this to the public. All right. So the next is we want to discuss Article 12. If I was looking over it, didn't we?
We did it.
We accepted all the changes to Article 12 except with the site plan review section.
except for, there were, I think, 2 or 3 items that had been
All right.
changed. in it,
So-
And
Woody, unless you want to stick around for the discussion
mean,
of site plan review.
You guys are charming and fun and stimulating, but thank you very much.
But
Thank-
as I said, when I
Nicely
do,
done. I particularly like, by the way, I like the idea of all these simplifications, but I also like the missing piece, which was the abandonment, moving it here. I think it fits like a glove, a hand in a glove.
Good, I'm
It should
glad.
have been here 70 years ago, I guess. So thank you very
all right,
much.
so, well, before you go, Woody, so our next meeting of the bylaw committee is going to be Monday, January 9th. And the other parts
Good.
of the changes to Article 8 we'll vote on as the first item of business that night. So
Okay.
you might just want to help participate. And then again, I would ask, and we can talk about this later. I'm proposing to the committee, and we'll vote on this later, to throw in another public forum the end of January to discuss solely these changes to Article 8 and separate them from the rest of the warrant that we're proposing.
Yeah,
Because I just,
You know, for
and,
the other.
I would look to you to help explain that, but again, whatever your comfort level is, I'm not going to put you on the
Well,
spot.
I mean, I'm comfortable, but the issue
Thank you.
is that, you know, I'm not a believer in a single forum. I don't know whether they all have to be done in Wilcott Common, but I'm always amazed in this town, I'm sure every town, people will show up and say, I didn't know anything about this. And you could have 10 sessions. And there are going to be
Yeah,
people,
well.
you know, this is a big news, but I would try to do more than one.
Yeah,
Uh,
well, yes, I mean, we
on a
have,
given topic, because you never know who's gonna say, I was out of town, I was sick, you know, something. You say,
right,
well, you
no,
were sick
I,
2 months
we'll
later.
just, yeah, we're gonna discuss that in our calendar. I mean, there's the planning board public hearings that, you know, there's another opportunity. There'll be all the other board reviews, your board advisory. I mean, there'll be plenty of opportunities, but as I said at the beginning of the meeting, Justin and I are looking for other ways to get the word
Yeah.
out too. And I think particularly as we're heading into town meeting, it's going to be important for us to get the actual text of these warrant articles out, not only just at the public forums, but in other other means as well, to get the text out there. So we're going to make sure we do that in this go around. So, but
Okay.
anyway, thank you for your help, and I'll talk to you.
Thank you.
for
Good luck, you
Merry
guys.
Christmas. Merry Christmas
I
to you. and
appreciate
Joe.
your doing it.
All right, thanks. All
Thank
right.
you, Woody.
Okay, you pretty
All
much voted on all the changes to Article 12. This is the December 14th, 2022 version that you got. It's version 2.
So I'm not screen sharing, so let me see. Where was that? All right. December, when was it?
December 14th, 2022. It should say Article 12, version 2.
Yeah. Aha. I think it's this one. Yeah, no, that's version 1. Never mind. I did see a version 2 somewhere. A printed version 2.
I have one that says edited version 1216. But I
No,
don't
that's
know if
that's
that's it.
the red line. That's the red line. The one December 14th, 2022 was the it shows the changes that were made.
Yeah, let me, hold on. Well, I mean.
They're almost all sort of small editorial changes. They don't change the context of what the board had, what the committee had talked about. Until we get to Article 12, really. Until, sorry, section 12.4 and sections 12.6 are really the sort of the meat of the changes. We don't have it.
I have something, Judge.
Jesus, what did I just do? Sorry.
That's all right. You probably got an email from me on December 14th.
No, I think I got it now.
15th.
this-
And then
You
it was
have it?
forwarded.
Yeah,
Can
Then it
everybody
was
see,
forwarded.
that is
can
it.
everybody see this Article 12? And
I'm
then-
looking at it.
Yes.
Okay, all right, so, and this at the very top does say V2, so it may
Yeah.
have your, all right.
Okay.
So if I, again, to cut through it in the interest of time, I think tell us where you still need our voter consensus.
Okay,
for this
we're
one.
going down to the changes you wanted on, let's see if I can get all the way down. We had questions still that had not been resolved under 12.5 special permits. Item is paragraph A 7, 5, and 7. I have highlighted. Screening and buffering with reference to type, dimensions, and character. I'm not quite sure what your intention was there.
Who wrote this, me?
No, this isn't the original, the original.
Yeah, I don't want to take credit for ambiguity.
Maybe it was in reference to like landscape.
I think
Landscape.
basically, yeah, I think it's to
Buffering.
give us some comment on a landscaping plan for a place. And it came up recently in a place that's gonna have like, what's the place in Situate Hill? How would you describe that? Like commercial with driveway, a commercial office and garage.
Tradesman Bay
spaces.
warehouse style, right?
A warehouse style building, and we had some screening put up. There's another one on 3A that's being rebuilt that we asked for screening against the residential neighborhood that it borders. So
Right. So is it the character of the use, or is it
I think
the?
the
dimensions
reference word,
of-
I think it's the word reference that's wrong.
Mhm.
I think it's screening and buffering and specify type, dimensions, or will review type, dimensions, and character. I think that would be the fix.
Well, no, this is the factor that the zoning board or the planning board is going to consider in granting a special permit. They want to make sure that satisfactory provisions have been made to prevent undue adverse effects on adjoining properties after considering the following factors. And so one of the factors is screening and buffering. Can we just leave it at screening and buffering?
yeah,
Yeah, well, but I guess
yeah,
I understand.
Or
But-
putting what Clark says is put type, dimensions, and character in parentheses after screening and buffering, basically.
Sure. Okay.
Yeah, that does it, because
Okay.
with reference to is kind of screwing up the flow.
Okay.
Now, you're
And then
saying,
economic effect and the
yeah,
general.
so that's in our existing bylaw?
Yeah.
Yeah.
Okay.
Yeah.
I am not aware. of
Tom, excuse me. I have another Zoom that they kind of just called me, kind of needed, but is David, you will stay through. I've looked at this part here that was sent on the 14th, and I'm fine with everything in there. But we will continue. David, you will continue so we have with a quorum.
Yep, I'll take the baton and keep the quorum going.
All right.
Okay,
good.
I'm sorry to do this, but anyway, I got to get to the other one. I think it's going very well. And again, Judge Cutler, thank you very much. You're invaluable.
Good
Okay,
night.
good
All
night.
right, thank you. All right, so does anybody ever recall making a special permit decision based on economics?
No, I mean, some of these issues that we have under special permit and site plan, they're kind of hard to kind of put your get a handle on, and they're sort of archaic in a way.
Judge Cutler, does this get us into trouble?
Oh, Tom, I don't know if you can see my hand raised.
Yeah, I'm sorry, I didn't see it, Lauren, sorry.
That's okay. I know it's hard when you're screen sharing sometimes. I just, for an example as to how you could consider economic effect is when we got the special permit in the Harbor Village for the Harbor Inn redevelopment, they submitted to us like an economic fiscal impact analysis where they discussed sort of like what the increase in tax revenue would be from the property, what you would get from like commercial, residential, what the difference would be, and sort of how that would economically impact the town. So that is sort of like a standard that you could consider, but I think you do need to frame it better because that was sort of their willingness to do that. That's not something that we explicitly require. And I do think it's an interesting lens to look at through things. But again, it's sort of another area to sort of go down a rabbit hole on, if you will.
Okay, but you want to separate it out from economic effect on adjacent properties and other properties in the district. It's more an economic impact to the town.
I would keep that in because I think you might not have used it, but it's one of those things like a tool in the tool belt that you don't need it until you need it. And you know, any project should be an economic net benefit to the town and the surrounding area. You know, especially if it's going to be a special permit. I mean, it should, you know, it should be a net detriment. I mean, so, and I know it's hard to picture because we have such little commercial property. So there's only going to be generally certain things, but you know, you could certainly see where some kind of business, I can't think off the top of my head, where it might be a big time detraction from everything around it, you know?
Well, I'll give you an example. The immediate prior application we had about Situate Hill was for a concept that was really coming out of the pandemic and that nobody was going to go back to the city for office space. And I don't know, in my own head, I didn't know that was going to be economically viable. So could I have been able to turn down the special permit on that basis, that I thought this was, you know, a new speculative type of venture that, you know,
No, I don't think so. I don't think you could look at the viability, but you could certainly look at what is the impact on the abutters economically, I guess. Economically, it's going to devalue their property, or it's going to, you know, that's a little different from that.
Well, all right, and that gets to my second comment, is that when we talk about compatibility and like not substantially more detrimental, I think of that as something other than economics. But are we talking in 7 the compatibility economically, or the compatibility and harmony just look-wise, use-wise? And should we separate, if you're getting the gist of what we're saying here on 7, separate economic impacts from, you know, an appearance compatibility and harmony, or a use compatibility and harmony. I don't know that we want to make compatibility strictly an economic equation. Does everybody get what I'm saying there?
Yeah, I hear what you're saying, but I mean, I think it's flexible enough to allow an applicant to pitch why this helps the area that the businesses that they're in. You know, maybe the reverse argument could be made for like marijuana dispensaries, but we have marijuana, medical marijuana locations in our zoning bylaws. But I just use that as an example. I think that that it works. I mean,
all right. Well, Judge Cutler, I don't know what guidance you know, either separate it, keep it together, reword it somehow, and what we are hearing here. But
okay, well, some of it I see. I don't know if Cassandra or Lauren brought it up, but one of the later portions of this, it says that when granting a special permit, the special permit granting authority wants to make sure that the granting the special permit will not cause conditions that are detrimental to abutting properties, to the public health, safety, or welfare, to the town's economy, or to the environment. Those 2 provisions are in the current bylaw.
Yeah, that's further down here in section E, and I'm just looking at that. And so
maybe what we want are 2 separate provisions here. One is the economic effect on the town, and the second one is the compatibility and harmony with the adjacent properties. And to David's point, compatibility and harmony sometimes has an economic characteristic within it.
For
Okay.
example, if somebody was proposing to put a gas station right next to another gas station, or
Right.
there's already 3 gas stations on a corner intersection, and they
Right.
want to put a 4th and tear down a perfectly nice grocery
Right.
store or whatever.
Right. So
That
when
would
you're
be
looking
an
at
example.
harmony and compatibility, you might say that's not really compatible because it's too many, so that would certainly be reasonable. Whereas the economic impact on the town is a little different. It's on the tax base, it's on services and costs of delivery.
Okay. All right. So then moving on, section E is somewhat similar, saying the same thing. So
Yeah, yeah,
I would leave it just as it's written there in the red and the yellow there.
okay, all right.
Now you highlighted the 2 years. Are you suggesting we change 2 years?
You can go to 3 years. Under the current statute, you can be up to 3 years if you want to be that generous. You can leave it at 2.
Yeah, I'm not in favor of generosity.
Well, during the Great Recession, the legislature and the governor voted to extend all permits for several times.
But let them make that decision. The town has had 2 years for quite some time in this bylaw, so I don't see any compelling need to change it. If this,
And there's a provision for,
By
except for
getting an
good
extension.
cause. There is a provision for except for good cause.
David, is your hand up from a while ago or up fresh?
That was from a while ago. The only thing I'd say is with E, and the previous one we had talked about, I think it's fine to a little bit of flexibility. You don't want the whole bylaw to turn into a pretzel, but to have a few places where you can be flexible and look at a project in its totality comes up with that, I think is good.
Okay.
Okay. So I don't think we made any changes to the variances, and then the site plan review. So last time we read my revisions to the site plan review, and we had some issues still. And Tom suggested that I put in the basically tailor the model site plan provision that I had provided to you last time. And so I tried to put it in here. It's a little difficult because the model or the sample that I had given you would have applied wherever it said site plan review applied in the use table. But since we're not going to do the use table yet, I sort of had to finesse that a little bit. I said in all zoning districts except the residential districts and the OS district. If you want to restrict that more, we can do that.
Well, we don't apply site plan review to the residential districts.
Well, right, currently you
Well,
don't,
a large home review is in sense a site plan in my mind, but
but it wouldn't be under.
that's a different topic we're going to deal with in a different way. So I don't have a problem with that language there with the restriction. Specifically saying that. I think it's stating the obvious that we don't deal with site plan review in a residential setting. Anybody Clark, any thought on that?
Yeah, well, there's existing non-conforming like commercial properties in residential districts. I'll bring up the 3A.
But if they're going to be changed, they're going to have to go for a special permit. And
special permit.
then the special permit granting authority can look at what the site looks like and
Not-
all of those things.
Not necessarily special permit with the planning board, though. No, I mean,
Well,
if
it's
like, for
non-conform-
example, I think the car place that does repair and sales in the middle of, in between the highway business district on the south and and then the one on the north, one in the middle between Pond and Beechwood. That one I think came in for a site plan review, because they were changing more than 200 square feet or adding more than 200 square feet, but it wasn't a special permit because it was in a
But if it was-
residential
if-
district.
But if it's a non-conforming use, it has to go for a special permit. And I think when we were just discussing the non-conforming section, actually Judge Cutler had a place to account for what we write here in this site plan review. Because it's,
It said if there were changes in those districts, it would apply.
right,
Okay, as long as we're covered for existing non-conforming
Yeah, I mean, I guess we
in
could say,
residential.
no building permit, as we do now, no building permit may be issued for construction of a new building or substantiation. We could say new commercial building or institutional, but I mean, my problem was saying, we said non-residential buildings, we've got institutional buildings, we've got schools, we've got churches, we've got, various things, town, municipal facilities and so on that would all fall into this. Now, if we want to cover those, we could say all non-residential buildings. But
Yeah, I just don't know if residential district does it. I'm sorry to open up a can of worms.
no, this is why we're discussing this.
no. I'm trying to think, Clark, out loud. Where would this occur? How would this occur in a residential district?
Well,
Any,
if
any
the gas
commer-
station, Robin's Garage or
Yeah, but they're non-conforming uses, so they would be subject to Article 8 if they wanted to make any changes.
Well, no, actually, Tom, they wouldn't be, only if they were reconstructing, only if they were that provision for reconstruction. There's no provision in
And that
the
would be-
just.
that would be ZBA, not planning board.
You get a special permit.
All right, well,
So if it was before the planning board, I'm sure would be looking at, how the site was developed, and that would all be part and parcel of whether or not it was going to be more impactful on me or more non-conforming.
all right,
I mean,
so
you can
then,
say any non-residential accepting municipal religious or, and then see
well,
what
I would,
happens.
well, let's say, in all zoning districts except the residential districts in the OS district, except
Actually,
commercial uses within those districts. No, well, wait, I wouldn't say that. It would say in all zoning districts except residential and OS, but not including commercial uses within those districts. No building permit may be issued, blah, 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 blah.
yeah, that might cover it.
That's what you want to capture, correct? Is that
Right.
a commercial use, not necessarily an institutional use, but a
Right,
commercial,
okay, so just commercial or industrial?
commercial industrial, yeah. I mean,
Okay,
again, as we define commercial, which
yes, okay,
we will at some point take that, when we change definitions, we're gonna have to go through the whole bylaw again.
Yeah.
make sure everything conforms, but.
okay. All
And-
right,
I know you
and
get
let
into
me-
trouble with non-residential if you're gonna put in a 50-unit apartment building, right? Because you'd want to be able to look at the 50-unit apartment building,
oh, well, that's a good point.
and it's residential.
All right, so except all zoning districts except residential and OS, but including commercial, mixed use and multifamily use. Commercial mixed use and multifamily use.
Family. Okay, all right, I will rewrite that provision. Okay. So under this provision, for those buildings it applies to.
Can I just, the whole point of rewriting this site plan section was what, again, just to refresh everybody's memory?
This was to really tie down when it applies and how it applies and what the
Okay.
process is. Okay. And so I just offered it as an alternative to what you had, which is a little confusing. And I just So we stuck it in here. So under this, it defines when it applies, and that would apply to a substantial alteration of a building. And that's an alteration that increases either 500 square feet of floor area or 10% of the existing gross floor area, whichever is less. Now you can change that to 200 feet like you have in your current. You could have it 5% of the gross floor area. And also it takes into account increased small incremental changes. So you can't have someone coming in just under the wire, not getting site plan review, coming in with another little addition the following year or 2 years later. And that's not
499,
it, so on.
499 square feet.
Yeah, so that I provided a provision in here so that you calculate that increase on the basis of the aggregate in the last 5-year period.
Today, those numbers are 210% or 200
I
and,
think it's just 200 square feet.
No percentage.
You have no
okay.
percentage, you just have 200 square feet.
Well, I think this is a good approach. I mean, it pegs it with the size and the area is increased, but I mean, I thought 200 square feet was ridiculous. That's like a single car garage size. So I think this makes sense.
Yeah, except that we're a small town with small sites generally.
Well, then if it's 10% of the existing gross floor area, the floor area is going to be in relation to the size
Yeah,
of the
all right,
building already.
all right.
That's the only thing.
Okay,
And then, or a change of use is a change from one principal use category to another principal, or from an accessory use to a principal use, where the change results in an increase in the number of parking spaces or loading spaces that are going to be required in Article 7. And then a substantial, the third possibility is if there's a substantial alteration of the parking loading or vehicular access. And there, I tied that again to increase of 500 square feet or more in the area of the lot devoted to parking, loading, or circulation, and emphasize that resurfacing is not one of those. Does not fall under that substantial alteration. So if you have one of those 3 categories, site plan review is required, planning board administers it. There's going to be a site plan application form and checklist. You get from the planning office, you submit it. Planning board has 21 days to consider it. I left out of there that whole public hearing requirement. I think that gets people confused. They think that there's some mandatory ability to appeal, all of those kinds of things. I think if the planning board wants to invite the public, I think, planning board can do that through its rules and regulations, or just decide this is a particular site plan that has, is going to have a lot of public interest, and we want people to be aware of what's going on, and you can simply send out a notice here that
there is no appeal process.
There is no appeal process other than anytime you have it, and same with your current administrative site plan. If you have an administrative site plan, the courts have said, and this is, I think, kind of roundabout, but they say you have to wait until you apply for a building permit, and then somebody has to appeal the denial of the building permit for not following the site plan approval or not getting the site plan approval. And that way you get to appeal.
Wasn't there something though that said like a long time ago about an appeal through, I can't remember what the chapter was. It was not anything in chapter 41 or 40.
No, it's, there's an administrative appeal process, and there's also
chapter 240.
There's a way to get around
Okay.
go to Superior Court on these things, but to a 40A appeal, but the court has said, no, that doesn't work here. You have to do it through 40A and section 8, and then that.
Right. Okay. Okay.
So the way this works then, and one of the things we talked about was modifications. So that was, back up.
I'm sorry. Yeah.
Yeah. So one of the things we talked about the last time was modifications and how do we deal with that? And under the current bylaw, it's very unclear, when you could modify it and how you modified it. So I have here that the planning board may allow minor modifications, and it's the planning board's decision as to whether or not they're minor. And if planning board doesn't find them minor, then they have to submit a new site plan application.
Okay.
So that's, that's still a little, I guess it's a little murky, but it leaves the planning board in the driver's seat on
No,
that.
it's like the change we talked about earlier, putting things to the boards rather than
Yeah.
to the building inspector making decisions. So I like that.
And then the building inspector can issue a certificate of occupancy until the site's developed in compliance with that plan. What I threw in here is in the event of completion is delayed by seasonal considerations, the building inspector can allow it to go a little longer.
All right. Now, let me just go back a minute. So down here, are 6 criteria for findings for a site plan approval. Those are gone
No, it went back up, up.
right here.
Nope, let's see.
Oh,
yeah.
all right. Oh, I'm sorry. So I'm sorry. All right. Yeah. Okay. I'm sorry. And then this disapproval section here, G.
Yeah, this is the only reasons why you would disapprove it. Doesn't comply, it does not, it's not complete application. So maybe you say you have to have a traffic study and they don't have one and they keep on not submitting it. You just go, you know what? You just didn't supply us with the information that we needed, we're denying it.
Okay.
The second option is it doesn't comply with the applicable use and development regulations of the zoning bylaw. So, their parking is inadequate, or the setback is wrong, or the height of the building is wrong, or whatever, you can deny it. But more importantly, if there's no set of conditions that you can, think up that are reasonable, that can address the issues that the planning board has found with it, then you can finally deny it. But for the most part, you wouldn't deny it, you put reasonable conditions on
Okay.
it.
So we have approval with perhaps conditions related to these 6 criteria that we have now.
Yeah.
And denial can only happen with these 3 criteria. Okay.
Yeah.
And in these 6, in the future, if we develop things with respect to both climate change and resiliency or low impact development standards, we can add to this later on.
Yeah. And, one of the things, I know you mentioned it earlier, but as you get into special permits for particular uses and so on, you can provide those as incentives, if you meet certain criteria that, that the town's promoting, you get a bonus of some kind, or, you get sort of points. So you can do that.
Okay.
The carrot instead of the stick.
Yeah, I assume when we go down the road of climate change and low impact development, it's all going to be about bonuses and incentives, at least for a while. Maybe 50 years, 30 years from now, they'll become so regular and routine you don't have to do that anymore. But
okay. One of the things we're trying to do here is keep this as very basically physical characteristics of the site as possible.
Yeah.
Here, you're really not doing too much else, right?
Okay.
That was the proposal. And so we can go either way. We can go back to what we talked about the last time.
No, consensus, guys. Do you like the site plan change? I mean, this is planning board territory. I'm good with it. Clark,
I mean, I'm pleased about the changes that I've seen. I would want to kind of reread it and just
right.
make sure that there isn't anything that jumps out after more careful study.
And I put in here what departments or boards that the planning board would circulate the copies of the application to. I don't think you have to have that in the bylaw. You could have that in your own regulations.
Right.
That's and I don't know if I've covered the whole kit and caboodle, whether there are others or what have you. I don't know. Lauren, do you have sort of a general circulation list now that you use?
We do have a general circulation list that we, interdepartmentally that we use.
Yeah.
I do want to flag, sorry, I was just in thought as I was looking through this. The only thing I'm concerned about is with the 21-day
Mm.
action deadline is, I mean, I know it brings it more in line with an A&R timeline, which we, it's never really been an issue, but there are scenarios in which you don't have a meeting for 3 weeks.
Good point.
And, it's just something to think about, like, in some case scenarios, like an A&R, like even if that, we haven't had a constructive approval, but if that did happen, it's like less detrimental, as you might think, than what a site plan review might do. So, that's just
Yeah,
something to think
certainly, I
about.
want you to think about those timeframes. They may be
Right.
too short for you.
Is
One of the-
20, is it dictated by state law?
No, it's not
No.
dictated by state law at all. All I was trying to do is make it so that it wasn't as onerous for somebody coming in with a 200 square foot addition to say, oh my God, I have to wait 6 months to get an approval of this. And so I wanted to, but if you wanted to make it 30, this is the meeting. They'll consider the board at a meeting held no less than 21 days, no more than 30 days after the receipt
Why
of
don't
the
we,
application.
why don't I suggest 30 and 36?
Yeah, 45 or whatever,
30
Yeah,
and
30 and
45.
45 sounds good.
30 and 45.
30 and 45. And then no more than 75 days after the receipt of the application, the board would file its written decision unless the applicant agrees to a later time. And this also provides that the planning board can continue its meetings. That doesn't mean, you hold it one day, but it does allow the applicant to agree to an extension that you can continue meeting on the site plan for no more than 60 days unless requested to do so in writing by the applicant. So if presumably the applicant said, yeah, I want you to continue it, and you're going 90 days, well, you're not going to issue a 75-day decision. So you're going to have to get an agreement from the applicant to extend the time for the decision as well. I don't know if you want to make that decision 100 days. That's more than 3 months. I don't know.
Yeah, I think this is fine.
Okay.
All right. All right. So we'll look at all of this before now. Like from my version, I'm going to bring up just a couple of topics.
Okay.
Do we want a provision in Article 12 that says no waivers?
No waivers from.
Anything from the bylaw? There was a provision I wrote that basically.
You have no right to grant a waiver unless the bylaw says you can grant waivers.
Well, I again, this was done on the user-friendly and simplistic thing is because we keep getting one particular attorney who asks for waivers all the time. And I wanted to just have a statement that the bylaw can't be waived.
But I mean, that's.
I know, it's stating the obvious.
I don't think you need to, and I think you run into a little bit of danger by even mentioning waivers.
Okay.
Right.
All right.
Tom, you could put that in regulations if you want to reiterate the fact, but
Yes.
people are doing their checklist.
Well, yeah,
but
well,
put it in the
the-
bylaw. It's like
Well, the
self-redundant.
funny thing is the regulations and the application materials and crap, we can waive that stuff.
You can waive, right? Yeah.
But I just, all right, that's fine. The second thing is, in my draft, it had a reference to a new table, would have been laying out all the timelines for people. Again, this is for the people who don't understand anything about the bylaw. And it would be a simple chart of all the application timelines and hearing
We
timelines.
talked about that, about having some kind of a friendly brochure to give out to people, to give them guidance.
Rather
on-
than in the bylaw. Okay, that's fine.
Yeah.
All right, that's fine. That's fine.
Or, it could be an appendix to the bylaw. Reference an appendix or something that.
Yeah, I just,
This is
again,
not
it's-
law, this is just, and then
Yeah,
you've
I
got
mean,
all kinds of disclaimers about we're not giving legal advice and,
yeah, I get it. Okay, all right. All right, so we'll circulate a final draft of this Article 12. Again, we'll take up whatever formal vote we need at the first instance at our next meeting.
Okay,
So for tonight, for articles, we are done.
So Tom, one quick thing.
Yeah.
I think somewhere, whether it's whether it's they said it in the regulations or the appendix or something, I think that thing about waivers has to go there, because you have to remember. I realize that it's, it should be obvious, but I think it's not just for this planning board, but it's also for future planning board. And so, you don't want another, not the attorney you're talking about, but any attorney coming up and doing the razzle dazzle and saying, here's our plan. And by the way, we want, 10 waivers on it, please.
Yeah.
So I think it needs to be memorialized somewhere. I guess it's a question of what's the best place to put it.
Right. All right. Well, we'll work it into regulations in the context of what can be waived under a regulation and what can and cannot be waived. That'll be a simple place to deal with. And Dave, by the way, that we do not deal in razzle dazzle. I have never BS'd a board. I've never BS'd another town's board in my life. Okay. All right. So for their next meeting, which our calendar, which I'm assuming we'll discuss this after you're gone, Judge Cutler. You don't have to hang around for the calendar discussion. But right now, it's tentatively January 9th.
Okay, and for that, you're going to be wanting to look at the final.
So
well,
we will do our final vote on the rest of Article 8,
right?
the entirety of Article 12, seeing it all in one fell swoop here. And you can distribute that, guys. That doesn't have to be distributed at this point in a red line version, does it? Clark, no. All right.
No.
All
But
right.
Fine.
Hey, Tom. I think you meant to, I thought you said January 8th for some reason. That's a Sunday. It's
No,
actually
it's
January 9th.
9th. No,
Yeah.
all right, sorry. Well, again, there's that addled mind. I'm sorry. January, all right, so we're going to do quick votes for the remainder of Article 8, Article 12, with a clean version of both distributed.
And you will have advanced Article 3 and 9.
Right, and I think in terms of how you organize Article 8 for the town meeting, if we're doing it in two articles, the single lot exemption would come at the end. It'd be the 8.7 and abandonment would move up to 8.6. So we'll be voting on 8.1 through 826 in one article, and then the single lot exemption changes in another article. We will also deal with at the next meeting Articles 3, just all the zoning districts, Article 6, which shouldn't be substantive at all. It's the sign regulation.
Right.
I will, again, Dave, you were here at the beginning. I will ask the alternate energy committee to have any recommendations they have in advance of the second January meeting, which is tentatively the 23rd. So we'll deal with articles, what are they, 19 and 20 on that meeting. As far as the definitions go, I would like to start on that at the next meeting. So again, if at the risk of repetition, any articles, any definitional changes that anybody on the committee feels needs to be made, and height is certainly one of them, or should be made, or something we can safely delete, or something you think should be added in the short term that we need it to be added now, a new term. Suggestions, please, before the meeting on the 9th. And Judge Cutler, if they're going through our existing definitions, if you, again, same for you, anything you think needs immediate change because it has some conflict with state law or decisional law, something we're missing that perhaps we should have in the short term. The height definition we have is out there. The version we've written, I'm sure you've seen it, but if the 210, December 21 town meeting, we got beaten up on the word street. We thought we were trying to just comply with state law, but if there's any definition we have that is, in conflict with state law or confusing with state law, let's change them now.
Right.
And then we'll get those ready for town meeting.
Okay.
Probably a lot of the new stuff will come in the fall because a lot of new stuff may be in conjunction with changes we make to the table of uses and the table of dimensional regulations.
Right.
Okay, so that's the game plan. If there's any other warrant articles that, for cleaning up sake, compliance with state laws sake, low-hanging fruit sake, that you think we can do and get done in a month and a half, feel free. And that goes for any member who has to suggest anything. Again, I know that I have some work to do on organizing regulatory stuff that the planning board can deal with outside this timeline. And I'm going to be working on that over the holidays. So we're good with Judge Cutler, unless anybody else has any questions for her. All right, we'll let you go. We have a little business to conduct still. Guys, it will take 15 minutes. I'm free. Judge, thank you.
Okay, thank you all very much.
Have a
Very helpful.
great holiday, and we'll see you on January 9th.
Okay, very good. Bye, everyone.
Right.
Thanks.
Let's get out of
Okay,
here.
good. Productive meeting, guys. Appreciate it. For the rest of our agenda tonight, we do have a schedule that Lauren and Cassandra have put together to get us moving around with planning board meetings. So we're looking at Monday the 9th, Monday the 23rd, and then Wednesday, February 1st. And by the end of February, we're going to have everything in place, because that's probably around the time, Lauren, correct me, that we'll have to have the warrant articles submitted.
Right. We're gonna have,
All right.
yeah, we're gonna have to put placeholders in, I would imagine, by the end of January.
Okay, all right. Well, Judge Cutler can give you a number. You know, it's looking like it. I think originally she said something around 10 articles.
Yeah.
I think with the split up of Article 8, maybe it's now 10. But
Right. And then
All
we
right,
just,
and-
we need the language in place for all of them when you advertise.
okay, and then still going forward with the idea, and Woody's point is well taken about getting these things out to the public, and talk to Justin briefly at town meeting about other things we can do, maybe using the Cohasset anchor more, or we do need to get the text of what we are going to propose out to the public in as many forms as possible, so that, you know, we can't expect total understanding of everything when we get to May at town meeting. Hopefully people have seen this stuff a number of times. So the forum to roll out the articles would be Monday, February 27th. Again, designed to bring it out early and get some feedback where we can make some changes even before we go to the planning board. What I wanted to propose tonight was Monday, January 30th, unless somebody tells me it's not a holiday, is it, of any kind? I think that we should roll out Article 8 changes separately and earlier. And Woody's correct that, you know, as we get into the March, April, and I don't know, when is town meeting scheduled for, by the way? They tentatively the 1st of May?
Correct.
Yeah, I mean, if we can work in another forum before that, after we go through the planning board process, you know, maybe in April, we'll see what we can do. But I you know, given the, you know, again, it was just a few people, but the feedback we had at the working group regarding Article 8, I think we should roll that out. So I'd like to have a vote to endorse this schedule, but adding a forum for that purpose for Article 8 on January 30th, if everybody's okay with it.
I just want to say
Yeah, I'm sorry.
when it does get rolled out, beyond the the full text of it, is maybe if there's a way we could come up with sort of a Cliff Notes bullet point version of what are the major changes that people need to know here.
Yeah.
And then, you know, that, because you're only going to be, because when you do the feed out, whether it's to the anchor or on Facebook or whatever, you know, that you're not just going to throw page after page of
No,
numbers.
no, and I think for a lot of the
Yeah.
other articles, that will be easy.
Yeah.
I think the single lot exemption needs first a very quick understanding of what it is. And even talking through tonight, you know, about the state law exception to the merger doctrine, I think Judge Cutler and I have a slightly different understanding of it, because I think lots of lawyers do, because it's a damn confusing statute. 48 Section 6 is one of the most confusing statutes you'll find. But we'll have to do that, you know, for the single lot exemption piece of it. We're going to have to explain what it is, why Cohasset's different. We're going to have to explain the whole Orleans example and the Supreme Judicial Court case so people understand the position that we're in. You know,
But-
we can maybe give real world, you know, we have a real world example of the lots that are now considered buildable that wouldn't be had the state, 48 Section 6 applied instead of our bylaw. We wouldn't be facing buildable lots in one place in town that we know of right now. And there's probably other situations that would come up. So I hear you. So I mean, I'm all ears on how to do this and
Well,
how to
we
roll.
always, when we do a zoning change, whatever the zoning change is, if it's warrant article number 11.
Yeah.
We describe the change, what has been changed, and then we have a layman's kind of version of it.
Yep.
That describes the purpose and why it's recommended, and so all those zoning articles are always in two parts.
And I, you know, but I think for publicity's sake, you know, we're going to use the anchor, maybe the 143 page, where we're not going to throw out the whole text, but at least give people the links where they can read it. And then what we link them to is a layman's explanation of everything we're doing, you know, what we have now, what we're doing, why we're doing it. You know, like I said, we can lead a horse to water, but we can't make them drink. People got to want to soak this stuff up. So we got to make the effort.
I think the thing when we get to the single lot exemption is it's going to be for the people who currently have a lot. They all they're going to want to know is how does it
My
change?
lot protected.
Yeah.
That's
And
what
you
they
know
want.
what?
That's it.
When we get a specific, like, for example, there was one gentleman who came to speak to us at the working group. And when you researched his particular lot, once you knew what it was and how the two lots were created, what was on them now, you realized that he didn't get any of those protections because he didn't qualify at all for the single lot exemption.
Yeah.
And you can do that when you get an individual property, but you know, when we guessed at the time that it was 76, that's because Katie Dugan went to the assessor's office and looked at certain codes. Well, assessing codes and zoning laws are a little different, and legal descriptions at the registry of deeds are all very different. And it would
Yes.
really require that we research the history of every property in town. Well, we can't do that. So
Yeah.
when somebody comes up to us for an example, and in this particular case, we could have, after the fact, said to this gentleman, well, you don't have rights anyway, and here's why. We can do that with particular examples, but and we'll probably get them, and we may have to go through that exercise of looking at the examples we get, but that may be helpful to tell people that no, we're not taking away a lot of rights here, because a lot of you who think you have rights actually do not, you know, and we'll have to deal with that as it comes, but there's no way for us to come up with a number to sell town meeting 76, 200. There's just no way for us to do that.
Yeah.
It's gonna have to be all case by case, but. All right, Cassandra Lauren, adding January 30th, is that a problem?
I think that should work. Another
Do you-
thought that
do
I
you
was
agree
having.
do you agree does everybody agree that we should treat Article 8 separate from the others in presenting them to the public? is it worth its own forum, in other words?
I think when it goes to town meeting, it's going to be separate anyway, so you might as well present it separate because the discussion is a little bit more separate, as
Yeah.
opposed to, you know what I mean? You could get hung up where you're talking about definitions and some of the basic things we're doing with a single lot discussion for the whole time, you know what I mean? So it would muddy the
Yeah.
waters. I think keeping them
Okay.
separate. That's
All right, I agree. And by the way, for town meeting, if we're going forward with 9 or 10 articles, I'm gonna propose that they be treated on a separate night. We not try to jam all of the annual town meeting on a Monday night, there's gonna be other things, and I think we're gonna need more than.
Tom, I
But
think we
that's-
should
that's-
try and
that's for
get
the
everything done in one night.
Well,
It's-
that's for
it's
the
a big
future.
burden for everybody.
I get it,
I
but
mean,
that's we'll talk
I'm
about
just
that in the
making that
future.
suggestion.
All right, Lauren, I'm sorry.
Just a couple of things. I think that's doable. And we can talk more details about this maybe tomorrow if you have time. Maybe we change up the format a little bit instead of like a forum style that we did this time as to more of like an
Yep.
open house, like workshop where people come in. You can have like a dedicated time where you do a little explanation in the front, but then like have people be able to talk to working group members and like ask these questions one-on-one, kind of have these examples. The other thing I think would be helpful is like if we're planning on expecting a lot of people to have all these questions, like having just a checklist in place of like these are all the pieces of information you need to figure out if to have a conversation as to what, because that's what we happen, like so often people will come in and be like ask a question. It's like without all this documentation or the background information, we can't just make a knee-jerk call, so those
right.
are ways that I think would be helpful to make it a little bit more for this purpose.
If that gentleman at this working group meeting had told me about his property beforehand, I would have had the answer at the meeting for him, but.
Right. So we can call them case studies or examples, a couple of case
All right.
studies or examples to
Right.
show how it works and how it works now.
Well, I was gonna lean heavily on Judge Cutler and Woody to be the presenters and main explainers of Article 8 at that particular forum. I mean, the other one, I think a forum format will be fine, but, so let's include the two of them in the discussion of how we present this one. I mean, I'm open to all ideas, and the other thing is, like the last forum showed us again, we're missing a whole demographic in town at these forums. We're not reaching a demographic who our town meeting do show up at town meeting as long as they have a special interest issue, they show up. A lot of them walked out when that vote finished. That's just my aside. But we are missing a demographic. Lauren and I have talked about babysitting and stuff like that. And
That has never happened before where people have gone to town meeting for one issue and left.
yeah, that happened last week, but
Oh,
if you noticed.
That would be,
Yeah,
Yes.
so no, but again, we're
Calling
missing,
people back to get a quorum again.
we're missing an important demographic in town, and I understand it. It's people with kids, and it's not that they're not interested in this stuff. It's just there's challenges to doing these at night. I don't know if the one unveiling all the articles maybe should be done on a Saturday. It's a winter Saturday. The only youth activity going on is basketball.
See, the
you
thing about
know.
the Saturday thing is we don't even do town meeting on a Saturday, and
We
quite
used
frankly,
to.
like
We
if
used
we
to.
don't, but we don't now, and people are so busy, it's difficult to staff on Saturdays. And I think, quite frankly, if you have people have an opportunity to spend a Saturday with their kids or do an activity or go to a zoning bylaw forum, I just don't think that's the answer to getting the demographic that you're missing.
Yeah, I'm just trying to shoot out ideas. I mean, are people gonna, even with babysitting, are people gonna come out on a Monday night? I don't know. But
But the rec center open house, I think we should have a booth there. I think that's a
Good
good
idea.
bet.
when
Yeah.
is
Already
that
set
again?
up.
When is that again?
It's usually in March.
yeah,
All
it's
right,
in March.
Yeah. All right, yeah.
Fine.
It's a good one. We just,
Yeah, and we'll have a lot of written
and
materials.
that's our demographic that we're missing.
Right. And then we can
Parents.
have our written materials explaining, the simple thing.
Yeah, we
What do
can have
have-
some
What do we
exciting
have now? What are
banners.
we doing? Why are we doing it?
posters.
Yeah, that
I-
would be great. Okay.
I dare say if we have the technology to do it, if we had a what are those things that you scan with your phone there, the little
Q
The little-
code.
QR codes.
QR
barcode?
code.
We can
If it-
definitely do that.
Yes,
Justin is all about those.
Jason is doing that already with the
Justin.
agendas of the, Justin, I'm sorry. Justin is already doing this stuff with these forums. He's had little QR codes and everything. I'm like, what the hell is that? You know, what does that could do? Am I gonna order takeout now? Whatever, but
No, they're terrific, and I think that's a great way that packets to people at that. You know, we might have a card with some stuff, but then on the card you've got the QR code that they can go in depth if they want to see everything from there. You know, that might be a great way. Those seem to work very well.
yeah, we'll do that and paper. I mean, I'm old fashioned and would like to see a piece of paper, but we'll do that. Yeah, so whenever that is in March, let's plan and we'll all take turns and shifts and everything and do that. All right. So everybody's okay with the schedule. We'll brainstorm ideas about the forums and how to conduct them, but we have the dates. All right, last thing is the minutes of the last meeting, November 30th, the motion to adopt them, accept them.
I haven't read them, so yes. So moved.
They're a thing of beauty, Clark. You should
No
read them.
doubt, no doubt.
They come out 5 minutes after the meeting. Geez.
Yeah, by the way, I'm not doing that tonight. I'll do it someday during the week at the office. I got some downtime this week. But, all right, David, second. All in favor?
Aye.
Tom Kelly and I.
David Frog, aye.
All right. Motion to adjourn. If less, Cassandra, Lauren, anything we need to know? Craziness? No? All right.
So moved.
All right.
And
roll call.
seconded.
And seconded. I'll second it. And I'm just making notes. Sorry. All in favor?
Clark Brewer, aye.
Tom Kelly and I.
David Frog, aye.
Have a great holiday.
Yeah. Holiday, great holiday. Thank you all for being here and getting this work done tonight. It was a good progress made. So we'll see you after the holidays.
Thanks, everybody. Happy holidays.
Thank
Bye.
you.
Happy holidays. Good night, everyone.
Bye.